Very good morning to everyone. I am Rainer Bruno from Group 2, along with Shafika, Dennis, Flavia, and Nohafiza. And we'll be presenting about void and voidable contract and its violating factors. Next slide. Next. All right. First, we discuss about what is void and voidable contract. A void contract is a contract that is not legally enforceable, meaning that neither party has legal recourse against the other party for a breach. A contract can be void from the beginning or become void due to certain circumstances, such as the contract involves illegal activities, is against public policies, is impossible to perform, and the party involved in the contract is not legally competent. A contract may be valid when it's executed, but later become void due to changes in the law or the circumstances of either party, making the contract impossible to fulfill. Some issues will make a contract void on its face, meaning that the contract written is void and cannot be amended to make it enforceable. Okay, next is voidable contract. A voidable contract is a legal contract between two parties where usually only one of the party has power over the others due to the contract terms. A voidable contract can be performed under the law. However, one party has the option to cancel the contract if any of the violating factors is involved, which we'll be discussing later. If defects are found in the contract, a contract can reject it. If the contract is not rejected, it remains voidable. That can be rectified. Okay, next slide. These are the violating factors: fraud, misrepresentation, mistake, undue influence, and concuss, which will be presented by my team members. Right? That's all for me.
All right. Thank you, Bruno. Today I'll be talking about coercion. But first, let me explain what is coercion. Coercion is a broad definition of the use of express or implied threats of violence or reprisal or other intimidation behavior that puts a person in immediate fear of the consequences in order to compel that person against his or her will. Actual violence, threat violence, or other acts of pressure may constitute coercion if they used to support an individual free will or consent. There are two types of coercion under Section 15 of the contract. First, coercion is committed where a person commits or threatens to commit any act forbidden by the penal code in order to cause another person to enter into an agreement. Extortion, causing grievous hurt, rape, and murder are the examples of acts forbidden by the penal code. Second, coercion is committed where a person unlawfully detains or threatens to detain the property of another person so as to procure his consent to the agreement. Coercion may take many forms. Persuasion becomes coercion when a person who influences another does so by threatening to take away something they possess, or by preventing from obtaining an advantage they would otherwise have obtained. So on the right side, I have two example cases. First, Twin Nambi development, which is threat against property. The defendant entered into sales and purchase agreement with the plaintiffs in relation to a house under construction for Rm 29,500 ringgit. So subsequently, the defendant demanded additional payment of Rm 4,000, or the house would be sold to another purchaser. In the end, the defendant paid the money. Case number 2 is Kusama Tumandas, which is threats to life and safety. Plaintiff executed transfer of land to defendant under the orders of the Sultan issued in the communist presence of two Japanese officers during the Japanese occupation of Malaya. And this concludes my presentation. Thank you very much.
Yes. Undue influence. Undue influence is happen when the relationship between the two parties, the person is able to convince other to decide. Sometimes due to the relevant status, high educations, or emotional relations, one of the party is in a position or domains over the others. The more influential person uses this leverage to coerce the other person into making choice that may not be in their best interested in the long term. undue influence is the law of undue is the law on undue influence is a contract is said to be a cause by the undue control if the relationship between the two continues. Without regard to the generality of the concept reference to above, an individual is an individual. The will of another is considered to be in a position to control. When an entity who is in a position to manipulate the will of another person enters into the contract with him, and on the face of it, on the evidence provided, the transactions appears to be the burdens of demonstrations that the contract was not caused by unfair interference. It exists the person in a position to dominate the will of the other must lie upon him. Next.
Okay, I will explain about the fraud. Fraud is under Section 17 of the Contract Act. A person commits fraud if he makes a suggestion of untrue fact, which is fraudulent misrepresentation, or actively conceals a fact, or has no intention to perform the promise, or perform any other act fitted to deceive. In other words, a person who commits fraud has no intention to deceive the other, and this is manifested in his action. Fraud also includes such act or omission that the law specially declares to be fraudulent. For example, where the disclosure of certain facts is required by law, the non-disclosure will amount to fraud. As a general rule, mere silence does not amount to fraud. For example, in a property transaction, the starting point is what? When two parties are negotiating, the seller does not have a duty to warn or disclose to the buyer the less desirable aspects of the property. There is no fraud so long as the seller does not actively conceal the certain facts concerning his property. Of course, this general rule comes with many exceptions. A buyer may demand that the seller warrants, guarantees, certain facts about the property as regards sales of goods. SOGA and CPA imply terms into contract such that subject to exclusion of liability, a seller effectively warrants the merchantable or acceptable quality of the goods, and so on. That's all for fraud.
Next is misrepresentations. Misrepresentation is a false statement made by one party of the material facts or the effects, the decision of the other party to consent to a contract. If the misrepresentation is found, the arrangement can be declared void to the contract. If the misrepresentation is found, the arrangement can be declared void, and the adversely affected party can claim damage depending on the case. Okay, how misrepresentations works is when refer only the statement or fact, not to view or projections. Misrepresentations, no matter the scale, is a ground for contract infringement and transactions. Example is a seller of a vehicle may misrepresent the number of miles to a prospective buyers, which could encourage the individual to purchase the vehicle. Okay, this another misrepresentation is have three types of misrepresentations. First is innocent misrepresentation. Second is negligent misrepresentation. Third is fraudulent misrepresentation. Okay, first is innocent misrepresentation. Innocent misrepresentation is a false declarations of material truth by the defendants who who was unaware that the declarations was misleading at the times of contract signing. Usually the solutions in this case is the terminations or cancellations of the contract. Second is the negligent misrepresentation. How is worked by executing a contract and assertions that the defendants did not try to check was valid. This is a the breach of the fair treatment principle that a party must undertake before entering into agreements. Examples is contract termination and likely penalties are the recommended for negligent misrepresentation. Lastly is a fraudulent misrepresentation. Is a argument that the defendants made it know to be a false, or the defendants made it is possible to persuade the other party to enter into an agreement. The injured party can sue to inviolate the defendant's contract and recover damage. Next.
Okay, now I will present about the mistake. There are three types of mistakes. The first one called a mistake of fact, section 12, where both the parties made a mistake concerning a fact essential to the agreement. The agreement is void. However, if both parties merely made a mistake concerning the value of the subject, such as like the quality or grade of goods, the agreement is not void on the ground of the mistake. Further, if merely one contracting party has made a mistake of fact, the contract is not void. For the second mistake is called mistake of law, section 22. A mistake as to any Malaysian law is force does not render a contract void. Where contracting parties make a mistake as to foreign law, this had the same effect as a mistake of fact. It renders the agreement void. For the third mistake is called a mistake as to identify of persons. The identify of contractual party is extremely important, and one is mistaken concerning this identity, the contract is void. For example, like Alex is a jeweler and Francis, a fraudster, went to the gallery impersonating a famous actor, Ben. Alex believed Francis to be Ben and sold him jewelry on credit. Alex intended to contract with Ben. The matter here is the identity was very important. The agreement can be aside on the ground that it is void for mistake. However, if the mistake was a concern a person attributes like his income, occupation, or status as opposed to his identity, the agreement is not void for mistake. Okay, for the conclusion, therefore, mistake is a vitiating factor of contract which gives effect to the contract being void or voidable. Thank you. That's all from our team.
Thank you.